Afternoon, and welcome to the 11th meeting of the Community Safety Advisory Commission. I so appreciate that you all came out in this weather. We are all beginning to probably feel like little duckies here, but thank you. Thank you for the location with some pretty, good parking and everything else. The first piece of business is approval of the minutes. And before I go there, I think I know of at least one correction. Mr. Wall, would you like to share that?
Yes, on page 8 of the minutes, my question number 6, will a review of the judiciary system be part of this process? My question was actually a review of the intersection between law enforcement and the judiciary system. That was my actual question.
So that's it's a fine point, but it's an important point, so thank you. So with that correction to the minutes, are there any other comments or concerns about the minutes as presented to the commissioners? If not, could I get a motion to approve them with the correction? Is that a motion? Yep. So moved. Is there a second?
Really quickly, I know I wasn't at the last meeting, but there were some questions and concerns around capturing of minutes. I apologize to everyone. I've been out of town. I haven't had a chance to read these minutes. But was those corrections around capturing conversations, if any other commissioners had a chance to read the minutes, are we at that stage where conversations are being captured?
I'm sorry, which conversations? Because at our last meeting, pursuant to the meeting before, we did have amended minutes per your comments from, again, I think it's 2 or 3 meetings ago. So I would say they were much more comprehensive in terms of what they captured. And so at our last meeting, 2 sets of minutes were actually approved. And now I'm not sure if you're thinking that there was something we missed, or if you're asking the question of the commissioners, are these now more comprehensive than they used to be?
Exactly. I'm asking, I guess, 2 questions then. Are the minutes more comprehensive, 1? 2, there was a lot of conversation in the last meeting I attended around what was missing from those prior minutes. And so my second question is, has that been amended?
Yes, those minutes were amended and presented to the commissioners at the last meeting, and they were approved. Now, from the commissioners who were at the last meeting, are you okay with these minutes in terms of their comprehensiveness?
I think these minutes are representative of the discussion we had at last meeting.
Okay, so I have a motion to approve. May I now have a second? Second. Any other questions or concerns? Then all in favor of approving these minutes, please raise your right hand, or you raise your hand, whichever one you choose. I'm sorry, I'm not swearing you in today. Thank you. Any opposed? The same sign. Thank you. So a couple of things. One is that I know since our last meeting, there was, and I'm sorry that I could not attend, there was a meeting of the hiring subcommission. Would we like to have just a brief update from those, from your meeting?
Sure. I think we had a really good meeting considering the amount of information that was presented to us. And so we looked at the overarching themes that were presented and then how we would chunk that information. And so we kind of developed 3 buckets that we would address and then the sub-information in those buckets. So we have on the calendar 4 meetings. And we have labeled those meetings according to the buckets that were developed with the commissioners. So we have, our next meeting is November 9th, and that will be specific to recruiting. The meeting after that is on November 29th for testing, December 11th for the selection process. And then in January, we're going to come together again to see what information do we have in terms of a next step deliverable, if you will, and if we need to capture that information and distribute some topics to other committees. So our first meeting, I think, is going to be pretty robust, and thanks to Emily, who is going to bring in an individual from the Franklin County Sheriff's Office. So in the spirit of benchmarking, their individual there, from our understanding, is successful in how they recruit individuals to the sheriff's office ranks. And then we're also going to be working with Elon in how we can bring in an officer who works specific to recruiting within the force to, again, benchmark internally. So we're going to have both of those prongs within the next meeting. So we are traveling along.
Thank you.
You're welcome.
And if we could get those meeting dates, times, and places out as quickly as possible to all of the commissioners. So again, you are encouraged and you are welcome to attend any of the committee meetings. And for the other committees, you are encouraged to reach out to Elon with the dates and times of your first meeting, because I think we've only had one meeting of the hiring committee. Okay, so please reach out to Elon on that. From our last meeting, and I think this occurred at the very end of the meeting, the chair received a question from the audience around, would there be an opportunity at a future meeting for members of the public to, whether it's to ask questions or to make comments? The answer to that is yes. We haven't specifically decided when. It makes sense to me that we would get through all of what I kind of call our fact-finding. So that's what these sessions, are. So somewhere between that work, the focus group meetings that the consultant is going to have, but before we start coming up with recommendations. So I'm just guessing at this point. We're probably talking about January, February. We will make sure that there is a public notice. There are always sort of rules around this, just the way there might be at City Council, and it's actually in our bylaws. But we will get that out to the public in plenty of time before that meeting occurs. But I wanted to reassure you that it will take place. With that, is there anything else of kind of a preliminary nature before we get into the meat of our conversation today? Good. Well, I am not going to read their bios. They were sent out to you ahead of time. But it's a real pleasure for me because for both of our presenters this afternoon, I have personally known them for a really, really, really long time. So Pam Gordon comes to us from the City Attorney's Office. She is the chief, and now I understand the title is Managing Attorney of the Labor and Employment section of the City Attorney's Office. And it was my distinct pleasure to welcome Pam to the office of the city attorney when I was the city attorney, and that's been a number of years ago. But Pam, it's good to see you. And for Ron Linville, who's the managing partner of his firm and who works with the city so much, I think Ron and I have probably known each other since at least 1980 because we have some mutual friends, but we have worked together over the years, including during the time that I was at the city attorney's office. And so I want to thank both of you for being here today. This session was scheduled from 2:15 to 3. We're running a little late, so it may be about 3:05, 3:10, but they're going to be presenting to us today. And this is, I know that the commissioners are always so attentive to the presentations, but in light, I think, of a lot of the things we've talked about, this may create the greatest mystery in terms of what happens, with police officers. We have a contract, and it's been described many ways, in my years. Some have said it's one of, in terms of, if you want, well, it covers a lot of things, and it's many times very difficult for members of the public to understand, specifically for an example, how a decision can be made by the safety director or the mayor, and then it's overturned by an arbitrator's, decision. That's just kind of, one area. So I'm sure that we're going to get lots of questions from this, and you will see there's kind of a general overview, and then there's a discussion of the general overview. Then there'll be a break, and then I think there'll be some real specificity between around 3:45 and 5 o'clock, and you'll see the specific articles, another break, and even more discussion. But this first part of the meeting today is a general overview. Pam and Ron, Floor is yours.
Ms. Jackson. I'm Ron Linville from the law firm of Baker Hostetler. I'm going to take kind of the lead on the first piece of this, but Pam is going to chime in whenever she wants, and then we'll sort of reverse orders for the second half of it. We have known each other, actually, I think it was earlier than 80, but maybe that's all the farther back you wanted to go, but I think it may have been a little longer than that. So I went to Wittenberg University and then Capital here in Columbus, and when I got out of Capital in 1980, I started practicing labor and employment law, and that's what I've done for the last 38 years. So I'm generally representing employers in matters relating to their unions or their employees. And some folks that have gotten to be very good friends would be on the other side of that, representing individuals or representing unions. I have had the, starting in about 84, and you'll see some of this history in the slides, when the public sector collective bargaining law was passed in Ohio, my practice kind of shifted to that world. And so a large part of what I've done my entire career is represent public entities, bus companies or cities or sometimes school districts, et cetera, but folks that are in the public sector related to their labor and employment issues. I've had the very good fortune to work with the City of Columbus since the mid-90s and have acted as chief negotiator for a number of rounds of bargaining. Since that time, been involved in lots of hearings related to collective bargaining. And so when George asked me to come and give a little presentation on labor law and collective bargaining, I was very pleased to be asked and happy to be here. We're going to run through a PowerPoint that I think you got in advance. And I believe the idea here is to help you kind of put the police contract that we have at the city sort of in context in the legal framework and the regulatory framework in which we have to operate in Ohio. We set aside some time for discussion after this, but I think we're both fine with questions as we go. So if you'd rather, throw something at me or ask a question as we're going, feel free and be happy to deal with it. So, yes, sir.
So I have a question, just for clarity's sake. So Pamela Gordon is representing the cities, and then you would be the counterbalance, representing the person who would normally speak for the?
We're both on the city side.
Okay, I'm just
We're
trying to
both-
understand.
Yeah. Pam is with the city attorney's office, and I'm with a private law firm that works with the city. But we're both on the employer side, the city side, in the employment issues and in the collective bargaining negotiations that goes on. So we actually work together and have over the years a lot. When I get hired to negotiate labor contracts, I'm not hired as a lawyer. I'm hired as a chief negotiator. So the city attorney's office and principally Pam and her folks do most of the legal advice giving that we need as we go through the collect. I am a lawyer and it's kind of hard to separate, but generally I'm hired as a chief negotiator for the city.
So that you spoke to the root of my question then. Will we hear from the employee, since you used the employer side, will we hear from the employee perspective relative to how the negotiation takes place and how we come to these final contracts?
I think, that's up to your commission, not today.
That had been considered, but.
The FOP, the entity, and do they have a specific law firm that they work with?
Sure. Actually, they've over the years had a couple, but so the Fraternal Order of Police is the union that represents the sworn personnel in the Division of Police, and Russ Carnahan, who has his own law firm, is principally their lawyer, although he's retiring at the end of this year or early next year. But yes, they do, and we've gotten to know a lot of the FOP folks over the years very well because of the issues that we end up talking about with them. No reason in the world, if the commission decided they wanted to have that you couldn't have. And my guess is they'd be fine coming and talking to you. But today you're getting it, this is really intended to be sort of more background and to put in perspective a little bit the legal and regulatory framework in which you have to operate when you're dealing with your unions, particularly in this case, the police. We can't really talk about the specifics of bargaining. I'm going to explain to you at some point where we stand with the police in the bargaining process, but I can't really get into any of the details of that because it's private between us and the union, and we're currently in bargaining. We can talk about the labor contract, and we will, but I can't really talk about the proposals or, what we've said at the table or that kind of thing.
And so to emphasize what Ron just said, they are currently in negotiations. Am I correct, Pam? They're currently in negotiations with the FOP right now.
And I'll tell you exactly where that all sits as we go through it.
Answered as you continue to talk, so I don't
Sure.
want to delay your presentation. But so, to be clear, the two of you are not part of the current contract negotiations with the FOP.
I am.
You
I'm
are.
the chief negotiator in the current contract negotiations with the police.
Negotiating for the city of Columbus, and I think you could probably go down the Public Safety Department, the Division of Police, but they represent the city, the employer.
Just one
So-
quick question too. At what rank does the union stop with the Columbus Police Department?
Sure. So, because of the way the statute, the law in Ohio reads, in police bargaining units, and we'll talk about what that means in a second, you can't have the promoted ranks and the police officers in the same bargaining unit, and I'll explain in a minute what that means. But it's police officers in one bargaining unit, and then it's sergeants and above in the other bargaining unit. And here in the city of Columbus, everybody in the division of police that's a sworn police officer is in a bargaining unit up to deputy chief. And then deputy chief and above are out of the bargaining units. But everybody below that is represented by the FOP. It's a good question. All these are good questions. I would guess that very close to 100% of the sworn personnel are members of the FOP. You don't have to be a member to be represented by the union. If you're in the bargaining unit, you're represented by the union. But as you can imagine, with police officers, there is a pretty tight-knit union, and so virtually everybody. If you looked at, for example, your AFSCME bargaining unit, the non-uniformed union, a number of the AFSCME employees, and I couldn't quote you how many, but several of them are not members of AFSCME. They are outside the union. And that's because of the First Amendment to the United States Constitution. As a public employee, that's the individual's choice, whether they want to be a member of the union or whether they don't want to be a member of the union. Good questions. I think most of this is going to get covered, but no, you fire away. So here are the things we're going to talk about today. We're going to talk about sort of what governs all this. Then I'm going to spend some time talking about the bargaining process and the concept of good faith. What happens if we can't reach agreement at the table? What's an unfair labor practice and how does that play into this? And then give you a little bit about where the negotiations sit with the Division of Police right now, and then Pam will take the lead on covering what the current labor contract provides. It is a very comprehensive, thick document, so we're not going to get through all of it, but we've kind of identified some areas that we think are most important. So just to give you a little background, for those of you that haven't dealt with unions or with employees that have organized into unions, this all goes back really to the 1930s, when the National Labor Relations Act was passed. The National Labor Relations Act deals with private sector employees, so with companies, not employees that work for cities or school boards or townships, et cetera. But that's where this all originated, back in 1935. Series of laws then, and that was, 1935 actually was the first time that there was a federal law that guaranteed to employees the right to form a union and provided the ground rules upon which, once a union was formed, how employers had to deal with that union. And, back in those days, it really was kind of the wild, wild west once unions were first getting organized. And unions and associations had existed before that, but this is when they were first kind of formally recognized. And that's when you may have heard of the National Labor Relations Board. That's the agency that administers that law to private sector folks. And, obviously, 5 members appointed by the president and confirmed by the Senate. So the public sector, now that's just to give you a little history on it. The public sector in Ohio, each state has its own kind of framework for collective bargaining and union, the way in which employers deal with unions in that state, in the public sector. There is the federal employees also have a different set of laws, but what we're really talking about today is Ohio in the public sector. And it was interesting, you see, going back to 47, there really wasn't much recognition for unions. There was a law that was called the Ferguson Act that was on the books from 1947 until 84 that actually prohibited strikes by public employees and said they could be terminated if they went on strike. Nobody ever did it, because if suddenly an entire school went on strike, if you fired all the teachers, what are you going to do? Who's going to teach kids? So it never really happened. It happened infrequently. But then really what happened is in the 70s and then in the 80s, there were a number of attempts to pass legislation, to pass a law in Ohio that provided the framework for collective bargaining between a public employer like the city of Columbus and the unions that represented their employees. That law came into effect January 1 of 1984. I was a fourth-year lawyer when it got passed, and so I've sort of grown up in my career with that law. And that's Chapter 4117 of the Ohio Revised Code, which is the Ohio Public Employee Collective Bargaining Act. CERB, if you've heard that term, CERB is the agency, like the NLRB, that is in charge of governing this law for the state of Ohio. The State Employment Relations Board, 3 members appointed by the governor, and that agency, CERB, sits at 65 East State Street, has been in effect since 1984, and is responsible for making sure that this law we're going to talk about that governs how employers have to deal with their union employees and their employees that are represented is administered. And so CERB decides when a union is the exclusive representative. They deal with unfair labor practices. They deal with all sorts of things related to unions and employers in the public sector. So there are, I thought it, you've already dove into it a little bit. There are lots of ways to get into this. So I thought I'd just start maybe with some of the key terms. And again, some of you may have more knowledge about this than others, so bear with me if I'm being too basic. But I thought I'd kind of start with some of the key terms, and then we'll kind of run through some of the other processes here. But so CERB, we just talked about, it's the agency, it's the state agency, like the Bureau of Workers' Comp or some other state agency, like this commission actually, that governs these relationships. An employee organization is a union, basically. It's a group of employees banding together to represent individuals. And so as that term is used in the law, employee organization basically means union. If you think of it kind of synonymously, it's the same thing. The next one is very important. So exclusive bargaining representative. So once you have employees that want to be represented by a union, and once they've chosen that union, then that union represents all of the employees in that group. Whether, very good question earlier about whether they're a member or not a member, but either way, if they're in the bargaining unit, then that union has to represent them all. And they are the exclusive representative, which means that no other union, individuals, nobody else can speak on behalf of that group of employees for purposes of collective bargaining. And we'll talk about what that means in a second. And so that term is really important, because once a union is certified as the exclusive representative, an employer can only deal with that union on mandatory subjects of bargaining, which again, we'll talk about. But basically, anything that affects the employee's terms and conditions of employment, their wages, their hours, the other working conditions, terms and conditions of employment. So I get questions all the time, why can't the city of Columbus just go to the sergeants in the Division of Police and talk to the sergeants about what they want to do? Because the FOP has been designated by law as the exclusive representative for the officers in the Division of Police. And legally, we have to deal with that organization as the exclusive representative. If you're not used to a union setting, if you haven't worked in a union setting or been around a union setting, some of these concepts seem a little different, but that's what the law requires. Bargaining unit, we've already talked about just a little bit. What that means is the group of employees that CERB and the law feel have very similar interests and ought to be grouped together for purposes of collective bargaining. So in a division of police, that's pretty simple, because the law says that with sworn police officers, like in the city of Columbus, the bargaining units are just those sworn officers. And it also says that you can't have the promoted ranks, the supervisory police officers, in the same bargaining unit as the police officers themselves. So in the city of Columbus, there are 2 bargaining units within the Division of Police for the sworn personnel. I keep using that term, sworn personnel, because that's very important. There are other employees in the Division of Police. There are civilian employees. There are folks that are represented by other unions that work in the Division of Police. But what we're talking about here in the FOP contract is the sworn personnel. And actually, there is one labor contract. Both bargaining units vote separately on that labor contract, but it's just housed in one place. So when we bargain with the police officers, and we bargain with the sergeants and above, all the ranks, sergeant and above.
So Ron, just one thing, and everyone may know this. So I think many times when we think of the sworn officers, we think of the officers in the cruisers. They wear the white shirts, in the summer. But that unit also includes homicide, burglary, robbery, any of those other special divisions. Unless they're at the sergeant level, they are all included as sworn personnel, correct?
They are, and they'd be in one of those 2 bargaining units. So it was a very good question earlier. Every police officer that is a sworn personnel, regardless of rank, is represented by the FOP in one of those 2 bargaining units. And the only ones that aren't are the deputy chiefs and the chief that are sworn personnel. And so that is of the 19, I'm not going to get the number exactly right, but what would it be, George, 1900-ish?
Approximately 1960 total with around 270, 280 civilian.
So of the 19, use the number 1960,
So 2,200 folks total.
1953 of them are in the bargaining units, and 6 or 7 are out.
And then another 250 or so.
And then the civilians are totally separate than this. And again, the reason for that is that the law believes that they have a community of interest, police officers with each other, and the promoted ranks with each other. Sure. Sure.
So every sworn officer, even if they're not in uniform, they're employed by the police department or the city, in the city, is a member of the FOP.
Does not have to be a member, but is in the bargaining
But-
unit represented by the FO.
And all of them are in the same bargaining unit together.
Police officers or sergeants and above.
Police officers, sergeants, and above, and those same groups of people can be also members of the FOP.
Sure.
And they're negotiating with the city
With the
for the
city of
contract.
Columbus.
And so the city negotiators include what departments? And are those departments sworn officers as well?
So, on the city side at the bargaining table, when we go to the bargaining table, you would always have a chief negotiator, somebody like me, that's sort of in charge of making sure things are moving along. And then we have representatives from a number of areas. You have someone from finance, because obviously the police want to talk about money. We have someone from the human resources area. They want to talk about insurance and other things that are related to human resources. We always have representatives from the Department of Public Safety, someone like George or his counterpart. We have someone from the Division of Police, several people from the Division of Police. But again, on our side of the bargaining, we refer to it as our side of the table, there are only 6 or 7 people that aren't in the bargaining unit that we can draw from to sit with us and negotiate the contract at the table. Everybody else would be on the FOP side of the bargaining table. So we try to get a broad spectrum of people that know policing, that know finance, that know human resources, that know public safety, that know the law, that have done this before, and that's how we sit and collectively bargain.
Do we currently have?
I was going to say
So we have
6.
6 deputy chiefs and the chief.
So
So
7
it's just
people
those 7 that aren't in a bargaining unit,
that aren't represented by the
aren't
FOP.
represented, that aren't
Exactly.
represented by the FOP, just those 7.
Yeah. And so when we go to the table, they've got 1,953 people they can draw from to bring to the table. We've got 7. Sure.
So those 7 people represent the best interests of the city and the people in this community on that side of the bargaining table?
Right. So it's, once you get to the table to bargain, the FOP is representing the interests of the officers and is trying to negotiate what they believe is in the best interest of their bargaining unit. So what are the best wages for their police officers? What are the best, what's the best insurance policy, et cetera? The city side is representing the city of Columbus, which would include lots of interests, including the interests of the citizens, the public. Sure.
And so the second question to that is, the other bargaining unit for sergeant and above,
Right?
are we discussing their contract in today's session as well?
Yes.
Or is that, okay,
Yes.
that's adjacent to what we're talking about here.
So what's commonly done, the law of 1984 required that you separate the bargaining units, thinking you shouldn't have supervisors in the same bargaining unit with the people they supervise. That's kind of the thinking. But most agencies that have 2 bargaining units like that, they still put it all in one book. So when we reach a deal, yes, exactly. So when we reach a deal, both of those bargaining units have to vote, and they vote separately, but then it's all in one book.
That the city, the 7 people from the city are bringing the public's interests, I don't know if this is on, the public's interests in introducing it. So how is that, that the public's interest captured? Is there like some issues that are raised or that just decided on by the city's representation in those conversations?
Sure.
How is the public's interest brought in?
Sure,
Can you
so,
talk more
so the city, the mayor, and the mayor's administration, and the Division of Police, as well as public safety, et cetera, the groups that I mentioned, all have to kind of decide what position the city wants to take at the table. And that would certainly include lots of information that the mayor's office and others have gained from members of the public. There is no member of the public not employed by the city at the table. Again, these are private negotiations between the union and the employer. But in terms of what proposals are made and what positions are taken, certainly there are lots of interests. Financial interest, can the city afford what it is that they want to do? But also, where is the public, on a number of issues. We get that at the bargaining table through the mayor's office and the other city employees that we work with. Anything else? This is good. Better to have questions and listen to me ramble about all this stuff, so fire away. The next 2 here kind of go together. When you have to bargain with a union, what do you have to bargain about? Is it everything? Is it just a few things? And what the law says is that you have to bargain in good faith, and we'll talk about what that means in a minute, about mandatory subjects of bargaining. And those are basically anything related to wages, hours, and other terms and conditions of employment. So when like your division of police, is represented by a union, and they demand collective bargaining. They want to go to the table and negotiate a contract. And by the way, you've had a labor contract with your police, with the FOP, in the city of Columbus for decades and decades and decades. But when we get together and bargain, we have to bargain. We don't have a choice. We can't say, you know what, this go around, we don't want to talk to you about wages. We have to bargain. We are legally obligated to bargain on any subject they want to talk about that is a mandatory subject of bargaining, which is anything related to wages, hours, and other terms and conditions of employment. And when you think about that for a while, wages, hours, terms, and conditions of employment is a broad definition. You know, think about where you work. What really isn't related to your wages, hours, terms, and other conditions of employment. So lots of things are included in the mandatory subject. But, yeah,
Mayor is the chief executive of the city.
right.
If he just said to everyone, I'm not bargaining on anything, which shows that he no good faith, what are the potential consequences?
Sure, it would be a violation of state law. You are obligated to bargain at certain times with the union, with the exclusive representative, and if you refuse to do it, it's an unfair labor practice. When we get to that, you'll see one of them is a failure to bargain in good faith, and if that happens, they file a charge at SERB, and SERB would order, and ultimately it would be a court, if it went that far, that would issue an order that you had to bargain. Yeah.
How often is the contract renegotiated?
Sure. So under Ohio law, this is different from state to state and different in the federal realm. You can't have a labor contract in Ohio with the public sector longer than 3 years. It can't expire more than 3 years from the date it's executed. So the longest it can be is 3 years, but it's up to the parties at the bargaining table to decide whether it should be shorter than that or not. Fact is, most common in Ohio in the public sector is a 3-year deal. Nobody really wants to get together and do this every year. It's a process you'll hear me talk about in a few minutes, and it is time consuming, and it is sometimes very passionate at the table, and so most of the labor contracts in Ohio would be 3 years. Can't be longer.
No contract. So currently, we have no contract, from my
Right.
understanding.
Right.
They're still in negotiation.
Right.
How long can they go with no contract and just continue negotiating?
So that depends on what group of employees you're talking about. But for the police, there is a process that I'm going to run through in a minute in detail that's called the dispute process. If we can't reach agreement, then they can't strike. And there's a process we have to go through. And once that process is resolved, the contract is settled. There is no specific time limit on that. So it could go on and on and on. You'll see here that in current negotiations, we expect the report from our fact finder, and I'll tell you what all that means in a minute, on November 27th. So bear with me. When I get to that, I'll make sure I answer your question. But there is no, unlike if it wasn't police, if it wasn't safety forces, it could go like this. With police and fire and other safety forces, there's a process that you have to go through. CODA, for example, if CODA and its union didn't reach agreement, it could go on and on and on and on and on and on.
We should mention that even though the contract has expired, we're still required to adhere to it until we get a new contract.
Okay.
That answers my question, because I was going to ask about this portion, past benefits and best practices, or does that go to that? So are you able to utilize or accept that certain parts of the contract are going to remain?
They all remain. So when the contract expires in the public sector, until you have finished the dispute resolution process that we'll talk about, you can't unilaterally change any term and condition of employment.
So where is the accountability then? So if the current conditions or obligations on the contract are in place until there's a new one,
Right.
is there accountability place where there's accountability to the police department still following the rules or whatever's in place in the current, whatever they're following?
Yes, so the union is still bound by the terms and conditions of the agreement. They can't ignore it, and the city can't unilaterally change. In other words, after the contract expired, the city couldn't say, you know what, sergeants, we're going to cut your pay by $1 an hour. You couldn't do it, because even though the contract has expired, you can't unilaterally change the terms and conditions. All very good questions. So good faith means that you meet at reasonable times and places, you come with an open mind, and that you listen to each other's arguments and discussions and points, and that you can't out of hand reject a position. You have to listen and discuss it and be open to it. It also means, as you'll see in a minute in one of the slides, that you don't have to agree to anything. Good faith does not require that you agree or that you compromise. It just requires that you have an open mind and that you listen to each other's perspectives at the table. Unilateral change, which is one of the other really, really fundamental concepts here that is critical. The city, once a union represents its employees, the city cannot unilaterally, on its own, without bargaining, change the terms and conditions of employment. It has to, it is mandatory that it bargain with the union before it changes a term and condition of employment. So the city's collective hands are tied, as are the unions, as are the FOPs, once they're representing the employees on anything that affects wages, hours, terms, and conditions of employment. Lots of questions if you're from a non-union setting where your boss can unilaterally come in and say, you know what, I'm giving you a raise, or you know what, I'm moving you over here, or I'm cutting your pay. When there is a union, the employer does not have the right to, on its own, unilaterally change things that are required to be bargained, that are mandatory subjects. A couple other things. Collective bargaining agreement is the written agreement. You'll see a slide about what has to be in it and what has not be in it. Impasse is a term that applies when the two parties have been bargaining. And, with the FOP, we've been bargaining since last September, September of 17. And you get to the point where you're done. You can't, future meetings are not going to do any good. You are unable to make any more movement on the issues you're talking about, and you are deadlocked, hopelessly deadlocked, sort of like when a jury can't come back with a verdict. And when you are at impasse, then we move to the next term there, which is dispute resolution. Sure.
Is there a frequency requirement in terms of how frequent or how often you meet?
No.
No?
The law, good faith, requires that you meet at reasonable times and places in a good faith effort to reach agreement. And so that's always kind of agreed upon between the parties. In some bargaining, you have ground rules where the parties agree up front, we're going to get together once a week for the next 4 months. In some, you just schedule as you go, but it's the only obligation is that you meet at reasonable times. The city couldn't say, you know what, FOP, we're not meeting with you unless it's at midnight. That's the only time we're going to meet with you. That would be unreasonable and in bad faith. But other than that, it's up to the parties to decide how frequently and how long.
Are the meetings open to the public?
No,
Are the
private.
they're private meetings, are the minutes available to the public?
No, private meetings. And the concept here is that in those bargaining sessions, you really do kind of roll up your sleeves and try and get issues out on the table and get them discussed. And if everybody knew that there was a recording made of it or that it was on, the public TV, et cetera, it would have, what the law believes is it would have a chilling effect on the ability of the parties to really speak freely. So no, those meetings are in private. Yes?
We use the language of bargaining for the union contract, but at these meetings, we're also bargaining to preserve management rights.
Oh, absolutely.
So the city side is trying to protect its interest and, flexibility,
You bet.
within the scope of the contract, right?
You bet. You bet. And I try not to refer to it as a union contract. I try to refer to it as the labor contract or the collective bargaining contract. Because it has both sides to it. Sure, it has rights for the union, it has rights for the city. Absolutely. And you're going to hear, Pam's going to talk about the management rights clause, which is in this labor contract sort of reserves to the city the right to run the place, subject to the other provisions, but that's exactly right. So dispute resolution is when the parties have tried, they're at impasse, they can't reach agreement. The law tells us what we have to do. And I'll explain all that to you in a couple minutes. The next term, in the public sector in Ohio, there are two groups of employees, two big groups. Some that are allowed to strike, so school teachers, school bus drivers, your parks and recreation people, your trash collectors. They are permitted to strike under the law. And then there are certain groups that are not permitted to strike by law. And that would be your safety forces generally. So police and fire for the city are the two largest groups. And those are, some are strike permissive, some are strike prohibitive. We'll talk in a minute about fact-finding and interest arbitration, but that's the process you have to go through. If you haven't reached agreement, you bring a neutral person in, and you present your arguments, and that neutral person issues a report and says, city, I think you're dead right on insurance, and it ought to be X, and FOP, I think you deserve a wage increase, and it ought to be Y. And then we'll talk about the next step if you still don't reach agreement, because fact-finding is not binding. It's only advisory. They're neutral. So it could be labor arbitrators, it could be professors, it could be labor lawyers. It's anyone that gets on the panel at SERB.
Okay.
And then the parties, and I'll explain how they select
Okay.
a fact finder. Management rights clause, we'll talk about all that when we get to the contract. And we'll talk about just cause, grievance, et cetera, and unfair labor practices. So, good faith bargaining, as I've said, the union only represents the employees if a majority of the employees have accepted that union. Once the union is there, it's there. It's not like every 2 years or 3 years you have to re-vote on whether the FOP is going to represent the police. They are there until a group of employees don't want them anymore, and there's a process called decertification for that. But basically, with the police, they've been there for decades and decades and will be, I'm sure. You see there the things that go into putting folks into a bargaining unit, and as we've talked about, Capital City Lodge, the FOP here, has 2 bargaining units. The duty to bargain, that's what we've already talked about. It's good faith. You have to meet at reasonable times and places about wages, hours, terms, and conditions of employment. And you have to be intent on trying to reach agreement. You can't come to the table and say, we're not going to talk to you, we're not going to reach agreement. You have to bargain in good faith. This is what I said earlier. You can make any proposal you want. You don't have to agree to what the other side wants, but you have to listen and act in good faith to discuss it. And again, the duty to bargain in good faith. So this is a concept we've touched on, but what do you have to bargain about? You have to bargain about anything that affects wages, hours, terms, and conditions of employment. There are in the statute several topics that are prohibited from bargaining. So you see them listed there. It's a fairly narrow, small group of things, but it's the conduct and grading of civil service exams. If the FOP came to us and said, we want to bargain about that, we are prohibited by state law from bargaining about topics like that. Otherwise, we have to bargain. There is a concept of a permissive subject of bargaining, something that doesn't affect wages, hours, terms, and conditions of employment, or that hasn't already been in the labor contract. It's a fairly small universe of stuff. And that's what this is. You aren't required to bargain on subjects reserved to management, but look at the underlined part. What the statute says is, unless they affect wages, hours, terms, and conditions of employment. So the ability to operate the division of police is a management right. There are lots of ways in which the division of police operates that affects wages, hours, terms, and conditions of employment. Telling people where they should report to work and what their job should be and who gets a job is a management right, except that it absolutely affects wages, hours, terms, and conditions of employment. So the labor contract has lots of provisions about seniority and bidding and who can get a job in what part or in what agent, in what department or subdivision of the division of police. So the labor contract, as I said earlier, has to be reduced to writing. Once you bargain and bargain and bargain, and you got a new labor contract, a new collective bargaining agreement, or CBA, it has to be reduced to writing. State law requires that it contain at least a couple things. It has to have a grievance procedure. You can't have a labor contract in the state of Ohio in the public sector unless it has a grievance procedure. What is that? So if in the old days, back in the 30s and 40s of the last century, when a union was upset with their employer, instead of trying to work it out, they could go on strike. And that's what happened all the time. Factories, manufacturing facilities, the machinist union didn't like what was going on. They'd take the employees out on strike to try and get what they wanted. So a grievance procedure and binding arbitration has been around as a way to resolve disputes once you have a labor contract. So we've got a labor contract, city's operating the division of police, a police officer thinks they're being paid improperly under the labor contract, they have the right to file a grievance. And that grievance gets processed through a procedure you'll hear about. And in the city of Columbus, like virtually every other labor contract in Ohio, the way that that grievance ultimately gets resolved is by an arbitrator, an arbitrator, a neutral person that comes in, gets hired by the parties, and issues a decision that is final and binding, can be appealed to court under very, very, very limited situation. So any dispute about what that labor contract means, or whether someone should have been fired, or whether they should have been disciplined, anything like that is subject to the grievance procedure. And the state statute requires that you have it. It doesn't say it has to end in arbitration. It says may culminate in arbitration. But virtually I think everyone I deal with, virtually everyone, does end up in arbitration, binding arbitration. The second thing that has to be in a labor contract is dues deduction. The police officers, City of Columbus, they pay dues to provide the FOP with the money to represent them. And you have to have a provision that permits the city, the procedure in which the city would deduct dues and remit those dues to the union. The next line here, you may have seen, there's been just a very recent Supreme Court decision of the United States Supreme Court, not Ohio, that it used to be that you had provisions in labor contracts that if someone didn't want to join the union, the question somebody asked earlier, I'm a police officer, FOP has to represent me, I don't want to be a member of the FOP. There used to be a provision in the labor contract that the FOP could collect money from me, even though I wasn't a member, and it was called a fair share fee. And the idea was I shouldn't get a free ride. I shouldn't have the FOP representing me and not have to pay anything for it. The United States Supreme Court said that is unconstitutional, so now there is no such thing as fair share fee anymore. You may have heard about that. And so, as somebody, good question earlier, you can't have it more than 3 years, and there are many places where the labor contract can supersede state law. So what is the bargaining process? We've already talked about this. You can't make unilateral changes. Oh, sure.
Your opinion or not.
Okay.
And so when you talk about the dismantling of unions, and as my grandfather worked 35 years at Buckeye Steel, retired, he got to go watch a union steel man.
Right.
The dismantling of unions, from my perspective, to bring the public's interests, and we're talking a lot about the police interests and the city's interests, but, and even in the presentation, and this is just my opinion, I want to say to everyone, I have to leave early, so I just got to get this out. There's not a lot of talking about the people's interests.
Yeah.
Unions, from what I know, I'm a 60s child, 61, when unions were strong and they fought for the people. A lot of what we know about coal mining and steel mining, my great-great-grandfather fought in the Civil War and the U.S. Colored Troops, was injured by a cannonball, unions and those kind of things, the protection of the people. And so this presentation just kind of feels like we have no power, and that the FOP, and I sit here representing the people, have power, even in how you're presenting representing how the city cannot, will not, shall not do whatever, or don't have the power to bring the people's interests in full display as we talk about a force that gets 80% of our budget, police and fire. I don't know if it's 80 still, but I just want that to go in the record. I would love for this to talk more about how people, and also, and then I'm going to ask another question, and if you can answer it, if not, Senate Bill 5 sought to address a lot of do some things to collective bargaining, and I don't see any of that in your presentation. Some of those things were dismantled around that time. Some of them were fought and repealed. So this union thing is really important to me. I work for an organization that protects rights of the people, the Ohio Organizing Collaborative. So this is a really interesting presentation. I thank you. But those are some things I would like to hear, like where are the rights of the people in unions, not just the police. And I haven't heard that yet, so.
Well, let me try and ramble around a little bit, and maybe I can respond to some of that. First of all, I don't know that I ever, and if I did, I apologize, I didn't mean to, said anything about dismantling unions. We've got a state law that tells us how we have to deal with each other. And there's nothing until you change the state law that the city or that the union can do about it. So this is not ever about dismantling the union or being anti-union or being, it's simply the process by which the unions represent the employee's interest and the employer represents whatever its constituents' interests are. The city of Columbus, I think I respectfully disagree. I think that the citizens and the public interest is absolutely represented at the bargaining table, but that has to be through the employer. It has to be through the city because that's what the law requires. The union can't deal and the citizens can't deal directly with each other. It has to be the union and the city. And that's, again, I'm just trying to explain to you the way the process is required to work. I have never, ever been and never will be anti-union. I've dealt all over the country, bargain labor contracts, probably 300 of them, and am very comfortable with the people on the other side of the table. They're representing their constituents, I'm representing mine, and 98% of the time we're able to put a deal together that helps both sides with the various parties that they represent.
I just want to follow up to that and it be really clear. I am a pro-union person. I feel personally, and many people that I represent feel personally, our Fraternal Order of Police, number 9, has too much power in this whole process of how we get to better policing. And so there's a conflict there. So I am a pro-union person completely. I believe in the power of unions and the people. But I feel like our police department, Fraternal Order of Police, number 9, has too much power over how we are police. And so I want to be clear in what I'm trying to say. Thank you.
Understood, sure. This is a quick concept. I won't spend a lot of time on this, but once a labor contract is resolved, once it's settled and executed and it's in place, then if there is a topic that's not covered by the labor contract, so for example, with the City of Columbus, when the city decided to use body cameras, that is certainly a decision that impacts wages, hours, terms, and conditions of employment. Police officers, primarily in patrol, that are wearing body cameras. That was something that was a mandatory subject of bargaining. It affected wages, hours, terms, and conditions of employment. And so there was an obligation during the life of the agreement, during the term of the agreement. In the middle of it, we still had to bargain. So you bargain for a new agreement, and then if there's a mandatory subject that you want to deal with, you have to bargain midterm as well. This is what I touched on earlier, direct dealing. The City of Columbus cannot deal directly with the police officers. They have to deal with the union on issues of, obviously they supervise them every day and they tell them where to go and how to police. But on issues of wages, hours, terms, and conditions of employment, you can't go deal directly. You can't go to one of the substations and get everybody together and say, what do you think your wage increase ought to be next year? You have to deal with the union. And the same for the public. Under this scenario, only the city has the obligation to deal with the union on behalf of these issues. What's the impasse? So we've now been at the table and you've bargained. You know that you have to bargain with the union. You know what you have to bargain with the union about. You've bargained and bargained and bargained, and you aren't there. You can't reach agreement on wages. You can't reach agreement on what their insurance ought to be. And 17 other issues are still unresolved. This is the process that you have to go through in Ohio unless the parties have agreed otherwise. And if you are not allowed to strike, like police aren't, then you see here the groups that aren't permitted to strike and the other groups. Basically, the process is 2 steps. First is fact-finding, and the second is either a strike, if you're allowed to strike in Ohio, or conciliation. And I'll explain what both of those mean. So the first step for every public employee is the same, it's fact-finding. Again, unless they've agreed otherwise with their union. And then after that, you either have the employees in the bargaining unit have a right to strike, or they are off to conciliation. So what do those terms mean? So this is kind of the impasse process. The way it works now is CERB assigns a mediator. What is a mediator? So CERB has mediators. Federal government has mediators. If the parties can't reach agreement, if they're almost at impasse or unable to reach agreement, a mediator is a person that has no authority to do anything, but comes to the table and offers suggestions, tries to help them look for ways to reach agreement. So in the course of the process, you have a mediator appointed. Sure.
What's the difference between a mediator and a tribunal of competent jurisdiction? Because it's written all through here. So are they similar? Is there some sort of competency level that's necessary for someone to act as a mediator? Or is that a person that's agreed upon by both parties? How do you get to be a mediator?
Good question. So 2 totally different functions. Mediator is an individual that, how do you get there? Generally, it's because they worked in this business and then became a mediator. They either worked for a union or worked for a company in labor relations, or maybe were a professor that taught labor relations. Somehow they were in the labor world, and then they applied for and got a job as a mediator. So the State Employment Relations Board has mediators that are employed there. The Federal Mediation and Conciliation Service, you may have heard of, also has mediators. And the function of a mediator is not to decide an issue. We're going to see in a second the function of the tribunals or of the fact finder or the conciliator is to make a decision. Okay, the mediator is just to offer ideas. So we want to give the FOP, this is an example, a 1% wage increase, and they want a 10% wage increase. The mediator would come in and try and get you to, compromise. They come up, they've done it a lot, they have ideas, but no authority, can't tell the city or the union what to do. But CERB, as a part of its process, has to appoint a mediator, and then basically the parties bargain, and then it's up to the parties to decide when they are at impasse. So CERB doesn't really do anything else until the parties say, we're stuck. And then either party can go to CERB, go to the state agency and say, we're stuck, we want you to give us a list of fact finders. And the first step in this process is fact finding. And so the way that works is CERB has a roster of, 80 or 90 people that are fact finders and conciliators, and they send the parties a list of 5. And they, as somebody asked earlier, a good question, who are they, what do they do? They can be lawyers, they can be labor relations professionals, professors, someone that has some knowledge about bargaining and labor relations. And then each side strikes 2, and you're left with 1, and that's your fact finder. And that's mandatory. You don't have any choice about that unless you've agreed otherwise. And in the city of Columbus, the collective bargaining agreement does not provide a procedure other than that. So this year, when we, and I'll explain the timelines, when we went to fact finding, we got 5 names. We kicked 2 of them off. They kicked 2 of them off. You alternate. And then the 5th person was a fellow named Mitch Goldberg, is our fact finder. And
What's the basis for striking fact finders? Is it an interview, or is it arbitrary, or is there a?
you do research on them, so all their prior decisions are available to us. And each side is trying to pick someone that is fair, that is honest, that has integrity, that isn't biased. On our side of the table, we wouldn't want a fact finder that was biased towards the union, and on their side of the table, they wouldn't want a fact finder that was biased towards management. But basically, what you want is someone who's smart and fair and has integrity. And so you look at their prior decisions, and you try and figure out, is he or she who we want? And some are more experienced than others. Some are maybe have more awards that you can look at than others, and you just try and use your best judgment. You talk to other people that have been in front of them. So we've got a community of hundreds of people that do what I do, and we send out an email and say, has anybody dealt with so-and-so, and what do you think? And you get opinions on how they did. You just try to bring your best judgment to bear to pick the fairest person of integrity that's going to resolve this dispute in the best way possible. It ain't perfect, but it's, kind of what you get. And you only get to pick from the folks that CERB have, and so that's what you do. So once you get a fact finder, so you can't resolve the contract, you're at impasse, you've asked CERB to give you a panel, you strike names, you pick the fact finder, then you are off to a hearing. At any time in this process, the parties can always reach agreement. So the day before a fact-finding hearing, the day after a fact-finding hearing, the parties could call each other up and say, I give. I'm willing to meet your side of, I'm willing to compromise, I'm willing to do what you want, etc. But generally, once you get to this point, you end up going to fact-finding. Fact-finding is a hearing. It's sort of like a mini trial or an arbitration, and the fact-finder is the hearing officer or the person that runs the hearing. And the way it works is you have to submit under the regulations, you have to submit prior to the hearing, the unresolved issues. So during bargaining, you've probably been able to get lots of things agreed to. But there might be 4 issues or 8 issues or 10 issues that you can't reach agreement on. So you have to send to the fact finder what those are, what your position is, and then you have a hearing where the fact finder listens to each side talk about why they believe he or she ought to recommend that side's position. So in my example a few minutes ago, why do we think the fact finder ought to give us the wage proposal we have on the table? The FOP would say, here's why we think you ought to give us the position we have on the table. And that hearing will go on and on and on until all the issues are heard. You have witnesses, you have exhibits, and all of that is trying to convince the fact finder of your position. You've been at the table and you've been trying to convince the other side of your proposal and your position. Now you're in a hearing trying to convince a neutral person. And the idea is that once the fact finder hears what everybody has to say, and the fact finder issues a report, that should try and get the parties together. So you go to the hearing after the fact finder is selected, and ultimately the fact finder will issue an award. So in our case with the police right now, that award's going to get issued on the 27th of November. And once you get the fact finder's award, it is a public document because it's the fact finder's recommendation on here's how I think you ought to figure out your new contract. Here's how, I know you were at impasse on these issues. Here's what I think the compromise ought to be. And that, as I said earlier, is not binding. So a fact finder's award is simply advice to both sides on here's how I, the fact finder, would settle your contract. And then each side has the opportunity to vote. So in the FOP situation, once the fact finder issues in this case, his decision, then the FOP will have meetings and their membership will vote on that recommendation. And it'll be separate, as I said, the police officers and sergeants and above. And then the city council has the right to vote. That vote has to take place within 7 days of when the report is issued. So in our case, the report's going to be issued on the 27th, and it has to be voted upon within 7 days. And if either side votes to reject by a 3/5 vote, contract is not settled. The fact finder's report is not adopted. So either side could reject. Either the FOP could say we don't like it, could be the police officers could say we don't like it, or the sergeants and above. That is a 3/5 majority of their total bargaining unit. So if there are, make up a number, 1,300 police officers, it has to be rejected. To be rejected, it has to be rejected by a 3/5 vote of their total membership. And it's 3/5 vote of city council. So even if a lot of people don't show up, it's still 3/5 of the total membership. The idea is that when you have a neutral that's looked at it and has issued a report, it should take a little bit more than a majority to reject it. It's probably got some wisdom in it, and you ought to think hard about it, and so the law requires that it would be rejected by a 3/5 vote. If you don't vote, it's deemed accepted. So if city council got the fact finder's report and didn't vote on it, it's the same as accepting it. And if neither side votes on it, you're done. The fact finder's award becomes then the new labor contract. We are at 3:25. You want me to keep rolling or take a break?
I've been sitting here thinking about that. Keep rolling.
Okay. Now, what happens if somebody rejects? So as I said earlier, if you're allowed to strike, if you're a school teacher or one of your non-uniformed employees for the city, then you have the right to strike, and that's a whole different scheme. With safety forces, you go to another hearing. And the second hearing is called conciliation, and there's a big difference between fact-finding and conciliation. And the big difference is that the conciliator issues an award that is binding. So in the public sector in Ohio, when you're negotiating with police or with fire, generally, there are a couple exceptions, but generally, the city ultimately can be told, and the union ultimately can be told, here's what the terms of your new contract are going to be, and that's by a conciliator. Conciliator is the same type of person as a fact finder. Fact finders do conciliation and conciliators do fact finding. The difference is, though, that once that report is issued, it's binding. So if in our case, either the FOP or the city reject Mitch Goldberg's report and recommendation, the next step, mandatory, is conciliation. And we'll go to another hearing, and we will present our issues and positions to another neutral, the conciliator. Couple things that are very important here. First, you can change your position. So if you got the fact finder's award and the fact finder recommended, if the FOP wanted 4% in wages and we wanted to give them 2% in wages, and the fact finder said 3%, then either side could say, you know what, we're going to live with that. And you can resolve those issues. You don't have to take everything to conciliation. By the way, these are completely hypothetical examples. I'm not talking about what's going on at the table at all. But you don't have to take all the same issues. You can compromise, you can continue to bargain, and the idea is that you'll get closer and closer and closer together, and the number of issues that would go to conciliation would hopefully be a lot less than what you took to fact-finding. Because you've had a neutral say to you, here's how I think you ought to resolve your problems. But if you can't, whatever you want to take, you take to conciliation. And a really fundamental difference is that when you present your position to a conciliator, the conciliator can't pick something in the middle. At fact-finding, the fact finder could fashion his or her own remedy. At conciliation, the conciliator has to pick either the city's position or the union's position. Can't put something in the middle, one or the other. And the idea is that if you're forced to make a final offer, you're going to get closer together. There was a situation, give me one sec, there was a situation years ago where I forget the employer, but the employer went to conciliation with a 0, didn't want to give any wage increase for 3 years. And the union came to the table asking for 10%. and it's final offer. And the conciliator said, I can't give them 0. My only other option is 10%, which is ridiculous, but it's the only other option I got. So the idea is you would never be that far apart. You try and get closer together. Yeah, sorry.
Same process of elimination for the conciliator?
Yes, you pick
5 and 2 eliminated? Okay.
From the same group?
Comes from yes.
But it's that same group? Fact finders and conciliators come from the same group?
We would never have the same person, but yes, same type.
But they seem 5 or 6 or however
I
many
think it's
you
5,
will.
and then it's striking, so is my number is striking. So that's the way it works, and you see, so what does the conciliator and the fact finder, what do they consider? You know, when you're there talking about insurance, and the city wants to modify the insurance program, and the union doesn't want us to, what are you talking about? Well, you look at the history of the labor contract. You can't underestimate, when you have a very mature labor contract that's been around for 40 years or 50 years, et cetera, how difficult it is to get a fact finder or a conciliator to change the language because of that number A, right there. Because it's been, the parties have bargained it before, it's in the labor contract, and so what's been in the contract carries a lot of weight with the neutral. The other things that they look at is, what are other police departments, in the case of the FOP, what are other police departments doing? So with wages, what are the wage increases that Gahanna and Upper Arlington and, Blendon and other places, what are the wage increases? What are the issues for people doing comparable work? And so that's a very big one. C is also a very big factor, and that is, can the city or the employer afford it? Can they, when you read the language, it's the ability of the public employer to finance and administer whatever it is the union wants. So the financial picture of the city or the school board or the township is very important to a fact finder or a conciliator. And if you're blessed, as we are in Columbus, to have a vibrant city with good economic situations, that's something that the fact finder and conciliator would take into effect. We, in every one of these hearings, generally have presentations on the city finances from finance director, auditor, something like that. Sure.
I want to do a kind of a touch point with the commissioners, because we are off schedule. But when I say that, that's good, because we've had great questions. But this is what Ron, is the PowerPoint your presentation?
Yes.
So it's to the end of this. So would it be okay if we went to about 3:45, which does put a little pressure on you to finish up?
Yep.
We will take a break, and then we'll see if there are any additional questions for Ron. He's received quite a few, but there are other commissioners who may want to have questions.
Okay.
Can we make that work?
So finish this in about 10 minutes?
Yes.
Got it.
Thank you.
Absolutely. Again, the decision has to be in writing. So I'm just going to touch briefly on what unfair labor practice, what they are. So the other big part of what CERB does is there are certain rules in public sector and labor relations, and if someone violates those rules, then it's called an unfair labor practice. And it's a charge, basically, that's filed with the State Employment Relations Board, and they do an investigation, and they decide whether or not the union committed an unfair labor practice, whether the employer committed an unfair labor practice, and then they have the power to issue remedies. There are ways in which those can be appealed to court, but ultimately, if a court upholds it, it's mandatory. So in the question, I think, Janet, that you asked earlier, if the city just said, heck with you, we're not going to meet, that would be an unfair labor practice, and after a hearing, CERB would issue a decision, and we'd have to do it legally, because it's state law. So what are they? Basically, the most important unfair labor practices for what we're talking about here is the one that says refuse to bargain collectively with the exclusive representative of the employees. So that can mean you failed to show up at all, It can mean you came to the table and you didn't act in good faith, which is really where you see most of those cases. But then if you fired someone because they were the union president, that would be an unfair labor practice. Their rights, the rights of the employees to form, organize, did I get them all? To form and organize a union are protected. So you can't discriminate against someone because they're a union president or a union steward or in the union movement or anything like that. State law prohibits it. So if in the middle of bargaining, the city fired the FOP chief negotiator, they could file an unfair labor practice charge. And you can see some of the others there, but those are the ones that are most relevant. And then there are also unfair labor practices that apply to unions. And again, they have to bargain in good faith if they refuse to meet or they refuse to bargain, because otherwise they could hold you hostage and you could never make change in your labor situation. So with that, we're gonna get to the provisions of the labor contract in more detail. So I'm gonna skip them here. We just had a couple slides about that. And we'll talk about them when we get there. So current status of bargaining with the FOP, and then we'll take a break. I'll do it better than 10 minutes. The current agreement with the FOP expired in December of 2017. It was a 3-year agreement. Somebody had a good question about how long they go. It was a 3-year agreement, and generally they are with the FOP. We started bargaining in September of 2017. You've already heard a little bit about the makeup of the bargaining teams. The FOP decides who on their side of the table they bring to the table. We don't tell them who to bring or who not to bring, and they don't tell us. They want to bring a group of folks that fairly represent the bargaining units that they represent. And so they have police officers, they have some folks from the promoted ranks, but that's their decision. In the city of Columbus with FOP 9, they call that their wage team. It's their bargaining team. And they have a chief negotiator. Their chief negotiator is always a member of the bargaining unit, or at least as long as I've been there, or a police officer or a sergeant or a lieutenant. And then they have Russ Carnahan, their lawyer, at the table with them. But their chief negotiator is a member of one of the bargaining units for the city. This time it's a guy named Mark Fester, and so Mark and I worked together to try and negotiate the labor contract. We met 22 times. They were generally 4, 5, 6 hour days. When you're in bargaining, it is not uncommon at all to break. It's what's called a caucus. So you're talking about an issue, then you listen to each other's positions, and you need some time to talk to the folks on your team so they can tell me I'm crazy or I'm not. And you break, you caucus. So not all of that time it's not 6 hours in a room staring at each other across the table. You have caucuses. Sometimes the chief negotiators meet. Sometimes you meet with a mediator. There are a lot of different ways in which you meet to try, and the goal is always to reach agreement on the contract, to try and compromise on the positions. You always start with your proposals. Each side comes to the table with the articles they think need changed, and they present those proposals, and you figure out a way to go through them, work through them by mutual agreement, and you work through the process. Unfortunately, with the FOP and the city, we were not able to resolve the issues. There are a number of issues that remained unresolved. Then we went, and the reason I mentioned the number is simply because it'll be in Goldberg's report, but we went to hearing, fact-finding hearing. We selected that alternate striking thing, and we got Mitch Goldberg, who is a labor arbitrator and has done a lot of labor relations stuff for many, many years. 5 days, full days of hearing with the fact finder on all of the issues. And as I said, his report is due on the 27th. So once we get that report, we'll analyze it, help the city kind of evaluate it. The union will be doing, the FOP will be doing the same thing. And then within 7 days, both sides will vote. They'll vote each bargaining unit. It'll go to city council, I assume, for a vote. It doesn't have to, but I assume it probably will. And we'll see where it goes. If both sides either fail to vote or accept it, we're done. And the contract will be anything we've previously agreed to, plus Mitch Goldberg's decision on the unresolved issues. If either side rejects, then we would be off to conciliation. And that would be the final and binding, final offer process that I talked about. So timing, we'll know by, I think council is going to vote on it on the 3rd, if I've got the date right. It's within 7 days of the 27th, I know that. I think it's the 3rd at their regularly scheduled meeting. And the FOP will have
Look at the calendar, the 27th is a Tuesday, so is that following,
Monday. I
is
would
that following Monday?
Yeah.
Okay,
Gives them 3 days to negotiate,
okay.
What's that?
so they only have 3 days to reject or accept.
They have 7 days, but in this case, they'll have, we always try and give them the most amount of time you can, but we never go right to the 7th day just because you don't want to screw it up. So this gives them, I think, 6 days to think about it and vote on it.
Right,
And the
3
same for the
business
FOP.
days.
And we try and schedule the timing of the award within 7 days of a council meeting so that they can deal with it. Generally, the FOP votes first. Most times, the union will have their informational meetings and then their votes first, so we oftentimes know what their position is. And as I said, the fact finder's report is a public document, so everybody in the room can see it and read it and figure out what.
Ron, I'm just curious, in your years of being with the city, has council ever rejected?
No, not to my
I
knowledge.
didn't think so.
You know, I may,
And what about the?
I don't think so.
On
Yes.
On the FOP side?
Yeah, you've had, I think firefighters rejected once since I've been doing it, and I think one of the bargaining units, I think the police officers accepted, and I think the sergeants and above rejected, but don't hold me to that, I could be wrong. But yes, I think the union side has rejected before, and I honestly can't remember, but I don't think city council has.
A lot of information presented in such a way that I think it's very understandable. Thank you. We're going to break until 3:55.
Will this be part of a meeting once this report is released, is my question.
The fact finding?
Is this part of a further future presentation? We discussed it in such detail, and it's a big part of the work.
We'll take that under advisement. Thank you.
You bet, thank you.
We'll break to 3:55. Questions of Ron, before we go into another area, because I want Sean to be able to hear everything, but, including the questions, but are there any additional questions? Matthew?
I have a question for you, sir. First of all, thank you. That was a good presentation. So on the slide that talks about the midterm changes, you talked about body cams. How far does that extend to other equipment or uniform areas?
You know, it's always a case-by-case basis, but basically, you have an obligation to bargain about any mandatory subject that isn't already addressed in the contract. So in the middle of the contract, the FOP couldn't come to the city and say, we want to bargain about wages, because it's already in the contract and it's addressed. Things like the body cam is something that wasn't addressed in the contract previously. And if it affects wages, hours, and terms and conditions of employment, then you have to sit down and bargain about it. And that's always kind of an evaluation of each situation. So the cruiser cams, for example, there was an agreement reached 15 years ago, 12 years ago about cruiser cams, body cams, the GPS system that's on all the police cruisers. There were some issues that the FOP wanted to talk about there. So there's a variety of things. It just sort of depends on what the issue is. And many times the FOP doesn't want to bargain about it, even though they might have the right. It's a question of whether they want to come to the table and discuss it in the middle of the contract. And you'll see in a minute, there is a provision in the labor contract for midterm bargaining that spells out exactly how it happens, when they have to notify the city, how many days you bargain, that kind of thing, so.
Clear, small example, big example. So if the chief said all officers have to carry backpacks with gear, that's obviously cumbersome, that's ridiculous. They would go to something for the midterm change. But if they said you have to carry 2 pair of handcuffs instead of 1, the
Yeah.
FOP may just say, okay, cool.
That's very good questions because, you know, on the body cams on the one side is, you know, probably a mandatory subject. Supervisory orders and directions on the other hand aren't. You know, you have the right to manage the place. And so it would take a lot more than we're changing the way in which you have to carry your backpack, or we're changing, you know, those kinds of things. So it's really different. You can't generalize. It sort of depends on the issue and whether or not it has an effect, even though the city has the right to make the management decision, whether it affects wages, hours, terms, and conditions of employment. So I wish I could be more specific, but there isn't just kind of a clear, bright line.
No,
This
that's
stuff
helpful.
is,
I
this
appreciate
stuff
it.
isn't, yeah.
Thank you.
But, you know, because you have a lot of direction every day that police officers get from their supervisors
Right.
that's not subject to bargaining.
Well, so I'll throw this out there so the commissioners know what I'm talking about. And I brought this up before, but as far as safety and wellness of officers, we've had some discussions around tourniquets, saying every officer should have, in my opinion, every officer should have a tourniquet issued to them. But that's something extra that would be on their belt and their bag. So looking forward to a possible recommendation from the commission, that's what's driving that question.
Fair enough.
Thank you.
Sorry about that, I ate a couple peanuts. I didn't know I was going to get another question.
Thank you. Andrea?
Curious if the new recruits in the academy are represented by the FOP?
They are not until one of the provisions you're going to see is once.
Couldn't hear the question?
Sorry.
No, maybe it was Andrea.
So the question was, are the new recruits in the academy represented? Not until they're sworn police officers. And then they serve a probationary period in the contract as well, which I think Pam will probably, I think it's in 10, isn't it? Yeah.
I think I have a question of whether or not something is actually in the contract or not now. And if you haven't had a ride along, I strongly suggest that you do one. I had one last week with Sergeant Justin Coleman out of the Main Street substation. Pardon? And as he reminded me, I've known him for a very, very, very long time. But I know that members of the commission have been concerned around the lack of diversity in the department, and then as you kind of go up in terms of promotions. So we had a discussion about what happens when you, in fact, take an exam. Of course, you pass it, and you're selected to be promoted. And then there's this issue of when that happens, you almost have to go to the bottom again. So if you've already become comfortable that Tuesdays and Wednesdays are your days off or whatever it is, and you're working 2 to 10, now you may have to work, you know, all weekends and everything else, and you've got to go to third shift. And his comment was that, you know, that really prevents a number of officers from seeking promotion. So the fact that this change in terms of you have to kind of go back to the end of the line again, is that in the contract?
I believe so. So the labor contract has a number of seniority provisions, including picking days off and shift, I believe. And I think it's by rank. I think it's your time in rank. We can double check. I'll take a look at it while Pam's running through them. But yes, so it's very common that even if you've been at the city 20 years, but you've only been a sergeant for a week, you wouldn't leapfrog over all the other sergeants that may have not been there 20 years, but have been a sergeant for 10 years. And so, yes, I believe that is what the seniority provisions say.
Any other questions?
So when we talked about the collective bargaining, one of the things says used to permit a fair share fee provision.
Right.
Was there a change that if you're part of the bargaining unit, but you don't want your dues to go, for example, here to the FOP, that you still have to pay your fees, but they will go to a nonprofit?
No. So after it was called Janus versus AFSCME, the Supreme Court said that it is unconstitutional to require someone to pay fair share fees at all. So if you are not a member of the union, and in the old days, there was a provision in the labor contract, I think it's Article 6, that said that they could collect money, so you have to pay for the services they're providing. That provision is now illegal and unconstitutional. Regardless of where the money would go, they can't require that a non-member pay a fair share fee.
If a member decides they don't want to be a member, they can step out, not pay their dues, and they are or are not?
So that's a different question, and
Okay.
that's a little bit more of the $64,000 question today. So in most unions, there is a process by which a member can become a non-member, and it differs across different unions. Some unions, it's within 2 months of the expiration of the labor contract, you can, drop out of your membership, et cetera. So there are several schools of thought today after this Supreme Court case. Supreme Court case comes down, it's never clear. It always creates lots of issues. And one is, if someone today, just use the FOP because we're talking about the FOP, said, I don't want to be a member anymore. And if the FOP's process required them to stay a member until a month before the contract, and I don't know what it is, but I'm sure they've got some process for being a member or not being a member. Question is, can you continue to deduct their dues? And I think that's still an unanswered question. There are some courts that are starting to deal with it, whether or not you can make someone stay a member when they signed up to be a member for some period of time after they said, I'm done, I don't want to be a member anymore. My guess is that given the current makeup of the Supreme Court, ultimately that will probably get decided, and you won't be able to require that someone stay a member, but I don't know that for sure, so don't take that one to the bank.
Thank you.
Sure.
So are non-dues paying members still eligible for representation for grievance or discipline?
Yeah, that's the whole concept of exclusive representative.
Okay.
So, and that's frankly part of the big controversy about this Supreme Court case, because now, again, this wouldn't be the FOP because I think they're almost 100% members. But if you had another union, and if only 50% of the people in the bargaining unit were members, that union has to represent, because they're the exclusive representative for the whole crew. And so they're only getting money from 50%, but they have to represent 100%. And so the unions, that's why the unions were so upset about this Janus decision, because it said you can't make someone who doesn't want to join the union, under the First Amendment to the United States Constitution, which applies to public employees, you can't require that someone join a group. You all have, under the First Amendment, rights of association, freedom of association. And so you can't say to a public employee, you've got to join a union. The private sector, unless there's a right to work law, the private sector, you can say that. You can say within X number of days, you have to join the union. But your constitutional rights as a public employee through the 14th Amendment, nobody can make you do that. So the issue is, if you can't make someone join a union, shouldn't they have to pay if they're getting served by the union? And the Supreme Court said no. First Amendment says you cannot force them to pay a fair share fee. Obviously, a very controversial decision. Unions, I've spoken on a couple panels with union folks, and they're beside themselves about it. What do you mean I have to represent that 50%, but they don't have to pay me anything? It has, they believe, has a very damaging impact on their ability to provide the services that they provide. Because, it takes a lot of money to hire union reps and to, get lawyers and to go to arbitration and all that. And if they don't have people paying for it, what are you gonna do? So it's a very controversial thing. Sure.
And then we'll get to Tracy.
So if the non-union members in the bargain unit, what happens if that threshold falls below 50%? And does that trigger something about exclusive representation?
Right, well, that's a good question. So there's a whole process that I didn't get into under CERB, where at certain times in the life of a labor contract, if employees don't want to be represented by the union anymore, they have the ability to file a petition at CERB, and then there's an election of the people in the bargaining unit to see whether they still want the union or they don't. Can't do it during the term of a contract, and I don't have the timeline, I'm sorry, memorized, but it's some period of time prior to when a contract expires. You don't see it very often in the public sector in Ohio. But there is a way, if people don't want a union anymore, if that bargaining unit doesn't want to be represented, that they can petition to have an election to decide whether the majority does or doesn't. But just being a member or not a member doesn't have any impact on their exclusive representation. These are great questions. You're testing me.
In regards to what Mr. Carter, the question about being represented in a grievance, if a non-member, they had the right to be represented as by the lodge, I guess the lodge has to, has to represent them. If a officer is involved in a critical incident, let's say a shooting, does the lodge then have to provide them with an attorney as well?
That's not governed by state law, to my knowledge. And Pam, this is probably a better question for you. I think that all depends on, first of all, if it's a disciplinary process, then yes, I think the rights under the labor contract would apply to that officer, member or not member. But I don't know in terms of whether they have to provide a lodge attorney on site for if it was an officer-involved shooting, I'm sorry, I don't know the details. But if it's a disciplinary issue and it's covered by the labor contract, then the same rights would apply to a non-member as a member. Again, with the FOP, there's a very strong membership, so we don't bump into that. You do with other unions more than you do with the FOP. Anything else? Yes, sir.
For clarity, the lodge and the union are the same thing?
Yes.
Okay, because I'm...
Number 9.
No, yeah. So
Okay,
union
right,
is
number
sort of,
nine's another term?
union is a generic term for an employee organization.
Oh, the Fraternal Order of Police.
In Ohio, there are two main groups that represent police officers. The FOP, Fraternal Order of Police, and in Central Ohio, the Capital City Lodge Number 9 is the lodge here, the group here, that represents 20-some bargaining units. And then the Ohio Police Benevolence Association, the OPBA, is another organization that would be kind of a competitor, I guess, maybe a little bit. They represent police officers as well around the state.
So then my next question is SERB. So SERB is these individuals are appointed by the governor?
Yes.
This is a state agency, like a regulatory agency.
Right. Exactly.
Does it not seem to make more sense that if you, just like you would select a jury, that you would bring individuals who are local for mediation, arbitration, conciliation, and then weed through them because they would be better informed?
It's a very good point. So the people that act as mediators are employed by SERB and employed by the Federal Mediation and Conciliation Service, but they generally are local, because the FMCS has offices in different parts of the state, and so they generally cover the area there. But fact finders and conciliators and arbitrators generally are Ohio folks, but doesn't have to be a Columbus person. I suppose you could probably agree to that if the union and the employer wanted to agree to it. But generally they could be, Mitch Goldberg, the one that's doing our case, is from Cleveland. So. Yeah, and there's probably a good argument, that's a very good thought, that someone that lives in the community might be better suited to deal with the issues of the two parties in the community. But, that's not the way the process exists in the state statute.
That'll be the last question for a moment. Okay, because I do have to move this us along today. Last one.
And I hate to ask the last question because it might not even be for you.
Okay.
But how, in what relationship is the Fraternal Order of Police in contact with other affinity groups like women police and police of color, and what relationship is required there?
I don't know the answer to that. I've never been a member of the FOP, and I'm not. I don't obviously go to their meetings, so I honestly don't know. I don't know if Pam has any idea, but I don't know.
And I say that just for context, just
Sure.
because in some cases there's a difference of opinion when the FOP is speaking out on behalf of police issues.
Oh, sure.
When some of those subgroups are in
Sure.
complete disagreement with it, and there's this, but I just know what the relationship was there and how that is represented.
And
I don't know if it was at our last meeting, and I don't know about women, maybe Tracy would know. For years, there was an organization in Columbus called POER, Police Officers for Equal Rights, I think that's what it was. And that was made up of, I'll say African Americans, not even at the time, people of color. It's my understanding from during this process, talking to some officers, it is essentially disbanded. And there's not been an effort. When you read the 21st Century Policing Report, you'll see reference in other cities where they actually have very strong organizations. But again, they're typically not a bargaining unit. They're there to represent in some way. And I don't know about women. No, I don't think so. Okay. Ms. Gordon, so to give you some context, because she's sitting over there saying, you know, they've used up all of my time, why don't we say this is 4:15? Why don't we say that you will go to 5:15? Let's try an hour and see where we are. We've got a couple of 15-minute things in here that we can work with or around, but I want the commission to be able to certainly hear you and all of the information that you're bringing to us, okay?
I do think that George is going to have me back at another meeting, so if we don't get through everything today, I can certainly pick that up.
You say, so this sets up the framework for internal affairs and investigations and discipline. This is, we're going to come back in a future session, go into great detail on that, and we'll talk about the arbitration procedure with respect to those disciplines.
So I'm Pam Gordon. I'm the chief of the Labor and Employment Section for City Attorney Zach Klein. You can see from my resume that I've been around state government and public service for a long time. I took a little break and did 3 years in private practice, and I wanted to come back to public service, and Janet was kind enough to bring me in on her team, so I appreciate that. I recognize Director Wilkinson as well. The group that I have, we have 4 attorneys that I supervise, that I manage. The purpose of our group is to represent management. We do all of the arbitrations for the city. We do any employment-related litigation for the city. So we don't get involved in the police officer shootings or those sorts of things, but anything that deals with the contract, that's what my group does. We've been talking about it. This is the collective bargaining agreement. It's a public record. As you can see, it's been reduced to writing. Wanted to follow up on just a few of the questions or comments that we talked about, just so you can see some of these things. And I've given you some handouts. I'm going to go through those, but I'm going to point out a couple of other things for you first. This might take a while. While I'm scrolling down, people always are amused that my undergraduate degree is in home economics. But I did not do any cooking or sewing in college, but that is my favorite pastime now. Okay. Oh, it's disappeared. Can I get some technical? It's just gone. I was trying to get to page 5. So while we're waiting for that, we had talked a lot about the bargaining unit. So Article 3, everything that we deal with is actually in the collective bargaining agreement. So Article 3 is our recognition section. This is where we set forth that the FOP is the exclusive, there it is the exclusive representative of all of the members of the bargaining unit. We also have a section that explains that the bargaining units, again, there are 2. The first is all full-time sworn police officers, so no probationary officers are not included in the bargaining unit, below the rank of sergeant. So those are your officers, the people that you see on the street all the time. That second bargaining unit, sergeants, commanders, lieutenants, those are the rest of them. That's it, yeah. Thank you so much. So there you can see here, so 2 bargaining units, and the FOP is the exclusive representative. I think we had also talked about the fact, we were talking about the fair share fee. And here we have this section. We're not enforcing this anymore. As soon as the Janus decision came out, we sent a message to our payroll people to not enforce this. But the contract did provide that if you were not a member of the union, you still had to pay a fair share fee. It's a lesser amount than what the members were paying, but we're not enforcing that anymore. We also had talked a little bit about dues deductions. Let's see if they're still here. I'm not sure, but I believe this contract does also have a provision for if a member wants to no longer be a member, what that process looks like. Right now, across the city, we're enforcing that with all of our contracts. So if the contract says you have to be a member until 30 days before the contract expires, we're enforcing that. To my knowledge, so far, we've only had perhaps maybe 3 people across the city say they were a member and they don't want to be a member. None of those have been FOP people. And as Ron said, I think there are only perhaps 4 people that I'm aware of who were Fair Share members. So everybody else is actually a member of the FOP. So we wanted to talk a little bit about some of the articles that we deal with the most. And I've given you some handouts. If you want to first take a look at Article 2. Get up there. So the first thing I think to keep in mind, Article 2.4, sanctity of the contract. The changes in this contract have to be negotiated between the city and I know we keep talking about we can't make unilateral changes, but we really can't make unilateral changes. If we want to make a change in the contract, we have to negotiate that with the city. I'm sorry, with the FOP. Section 2.7, and I imagine you might have some questions about this, so please feel free to jump in. Past benefits and practices. The city has agreed that we'll continue all existing practices and benefits during the term of the contract. What are those things? Well, a benefit, and it's defined in the contract. If we go back to the definition section of the contract, we have one. A past benefit is a policy, procedure, or practice that's been continuous and has a cost factor to the city and/or a monetary benefit to a member. It's a strange definition, but think about, we used to have take-home cars. So we might have had a policy where officers could take their car home, park it, and then drive it back to work the next day. That has a cost to the city. It's a monetary benefit to the member. If the city wanted to change that unilaterally, we'd be in trouble. We would be in violation of the contract because that's a past benefit that's been in practice. So we can't change those on our own. A past practice is a policy, procedure, or practice which has been continuous and does not have a cost factor or monetary benefit to the member. So you can see it really covers pretty much everything. Those would be things like changes to division directives, changes to days off, and we've had a couple of arbitrations where the city wanted to change days off. It was the vice squad, and I see some of my FOP people back there, hopefully no vice people. But the commander had wanted to change the vice days off to Thursday, Friday. They took that to the chief of police, and the chief of police said, no, not doing it. Commander said, well, okay, thanks very much, chief. We won't do that. But if there's an operational need, we might vary their hours, and maybe they can take Tuesday and Wednesday off. Or I'm sorry, Thursday and Friday off. They wanted Tuesday and Wednesday. I'm backing up. So in any event, they started taking Thursday and Friday off, which wasn't really good for the division because that's when most of your vice activity is happening. But unbeknownst to the chief, that practice was going on, and it went on for about 3 years. When the chief found out, they said, no, we're changing it back to Tuesday and Wednesday, and they did it unilaterally. FOP filed a grievance and said, no, can't do that. We have a past practice of having Thursday and Friday off. Well, if you look at this contract, it says that the chief of police, with the approval of public safety, determines all past practices and benefits. So we argue the chief of police didn't establish that, they didn't approve it, and in fact, he'd said, no, we're not having it. It went to arbitration. Arbitrator decided, much to our surprise, that it doesn't necessarily have to be the chief of police, even though that's what that section says. He said anybody that had a reasonable, it was actually a lieutenant. He said it was sufficient to find a past practice. The arbitrator was looking for mutual acceptance. And he said that determined that mutual acceptance requires that a responsible representative of the city have knowledge of the practice, accept it, and regard it as the standard practice. So sometimes even though we have language that we think makes sense and supports our position, it's up to the arbitrator. When we take those to the arbitrator, they make their decision. It's final and binding. And for the most part, we have to live with that. Questions about past practice, because I think this is what confuses people a lot.
So going back, the arbitrator is the conciliator in his case?
In our case, it's the arbitrator that's been selected pursuant to the collective bargaining agreement.
Okay, so it's a different process?
Yeah.
By which you select an arbitrator, and then their decision is binding?
Yes.
Okay.
Yeah, and I'm going to get to the arbitration provision, but basically what we have are a panel of 6 arbitrators. The FOP and the city get names together, and it's sort of the same process where we say, hey, we want names of people who might be good arbitrators. We look at those, we research them, decide who we think might be good. We strike the panel. So we might start off with 10 or 12 people. We end up with 6. And in this particular contract, it's a permanent panel. So it's the same 6 people for the life of the contract unless we remove somebody. And the way that process works, and again, we'll get to that, but when it comes time for an arbitration, we have what we call that pool of 6. And we have to say, well, we've got to select somebody. We do it randomly. We put the names in a hat. We draw a name. Whoever that person was selected, that's the arbitrator for that particular arbitration. Then we have a pool now of 5. So when the next arbitration comes in, we put those 5 names in a hat, pull one out, that's the arbitrator. And we keep doing that until we go through all 6 of the arbitrators, and then everybody goes back into the pool.
I'm not saying this for you, Sean, but get down too bogged down into the
Okay.
whole arbitration process today, because I think it's going to be maybe
It
a
is.
part of it. But I am recalling, I think I am, so maybe some of you will remember, and I don't know if it would be beneficial to get it for the commissioners this year. Wasn't there kind of an in-depth article in the Dispatch in the last several months about arbitration and arbitrators?
I think there have been several.
We might want to take a look at some to see if it just might be additive to our knowledge around this. I don't recall exactly when it was, but it might be helpful.
But it might be helpful to explain. I think we're thinking, and I had to ask Ron this question at the break, that arbitration, fact-finding, and conciliation are different.
Yes, yes,
Okay.
yes.
So my question was about guidance for past practices. Is there any timeline associated with that before it becomes a past practice? So if a lieutenant approves something that the chief disagrees with, but they have been practicing it for 5 months, is that now a past practice, or is there some time where that would need to be in place?
Yes, it has to be continuous, and so the arbitrator is looking for how long has this been going on. In the particular issue with the vice days off, it had been going on for 3 years, and everybody was aware of it, but nobody had stopped it. And he said, well, that's continuous. 5 months, I would say, would not be continuous.
Okay, and who decides the threshold for what continuous is? Is there some legal definition behind that, or?
There's no legal definition. As we say, the chief of police is supposed to make that determination, but if the union disagrees and says, we think it was a past practice, even though the chief said it wasn't, then that goes to, go through the grievance procedure and go on to binding arbitration.
Thank you.
So it's done pretty much on a case-by-case basis, but we're looking at continuous in terms of years, not just a couple of months. So then we also talked about management rights, and so if you want to take a look at Article 7. So this is our management rights clause. And as you can see, except to the extent otherwise limited or modified by the contract, the city retains the right and responsibility, regardless of the frequency of exercise, to operate and manage its affairs in each and every respect. And then the contract goes through a list of things that are specifically reserved to management, and you can see those there. But you have to keep in mind that language, limited or modified by the contract. So there are certain things that even though they're reserved to management, if we have bargained over them, if they're in the contract, or again, if they're a past practice or benefit, our management rights are going to be somewhat limited. I think one of the good examples of that is Section 7.1.f, because there we have the right to do promotions and transfers, but we also have specifically in the contract included provisions about promotions and transfers. So our management rights are somewhat limited because we have to follow those express terms of the contract. Then if you want to take a look at Article 8, and again, when I come back, we're going to go into more depth with this. But this is where we have so much interaction with the contract. This is internal investigation procedures. It's very comprehensive, is the best way to say it. But oddly enough, we have very few arbitrations over this clause. I think there might be several grievances filed over these, but most of these get resolved before they ever get to arbitration. So if we're taking a look first at Article 8, this is the one that deals with how our investigations handled. And everything related to an investigation is pretty much listed in this contract. 8.1 deals with the procedures to be used for internal investigations. And it defines what an investigation is. 8.2 is the right to representation. Whether you're a witness or focus of an investigation, the member has a right to lodge representation. That just means when they're being interviewed by Internal Affairs, they have the right to have a lodge representative with them while that interview is going on. I think 8.8 is sort of interesting because it deals with the recording of interviews. And pursuant to this contract, all interviews actually have to be recorded. So those end up being public record. They're not always transcribed, but there's an audio there. If somebody wants to hear the audio recording, they can make a public records request and they can get that. 8.9 is a little bit confusing, but we're going to deal with that again when I come back. It's called insubordination, but what we're really talking about is when can you require an individual, one of the bargaining unit members, to make a statement to Internal Affairs. If this is going to lead to criminal conduct, a person obviously they don't have to incriminate themselves, so they don't have to speak. So if this is going to lead to criminal conduct and the person says, I'm not talking to you, we're like, fine, you don't have to talk to us. They can't be charged with insubordination. But if the employer says, you know what, I don't care about the criminal stuff, we're not going to charge you criminally, and nothing you say to me will be used in a criminal proceeding, then I can order you to talk, and if you don't, I can charge you with insubordination. You don't have to talk, but you're going to get in trouble for it. 811 is interesting as well because it deals with polygraphs. The city has the ability to do polygraphs, but I would say from my experience, it very rarely happens in Internal Affairs investigations. The article deals with when you can conduct a polygraph and who can be polygraphed, but it just doesn't happen very often. But again, it's one of those provisions that's here. If that issue comes up, we don't decide on our own how we're going to handle that. We have to go to the contract and say, well, if we want to conduct a polygraph, this is how we have to handle it. 8.12 are complaints, and this is probably where we have the most, I don't want to say, let's just say that we deal with 8.12 quite often. So 8.12 are complaints, and the first thing we have are citizens' complaints, and that also includes anonymous complaints. And so these are obviously complaints by citizens, not members. Members have the right to file a complaint against each other, but that's not what we're talking about here. So in order to be investigated, a citizen complaint has to be received within 60 days of the date of the event in question. Not within 60 days of the date that somebody gains knowledge, because usually, remember, you hear stuff like know or should have known. That's not the standard here. It's 60 days from the date of the event. If it comes in day 61, unless there's an exception, IAB is not going to investigate that. There are, though, some exceptions, and that's if it's criminal on its face. You can see it here in B1, the exceptions. If it's criminal on its face, then the 60-day limit doesn't apply. If it could reasonably lead to criminal prosecution, then the 60-day limit doesn't apply. But otherwise, 60 days and there's a cutoff. And then section 8.3, access to records. This is interesting because you might think if I'm the focus of an investigation, why would I be able to get all of the information related to the investigation before I'm interviewed? But that's what's in the contract, so that's what happens. The focus has the right to request records that the division has. If they are subject to public records law, in other words, we disclose them if the public asks for them, then the member will get that, and they'll get that before the interview. Section 8.14 is also one that we have a lot of interaction over, and it's really the second paragraph. And this deals with the timeframes that IAB, Internal Affairs, has to actually investigate a complaint. The investigation has to be concluded within 90 days after the date the city receives it. And that is set in stone. The city can ask the FOP if they'll extend that deadline. The FOP can agree to that. The contract says that they should not unreasonably withhold their consent, and they generally don't. I think that the city and the FOP actually work very well together on this. But, I'm sorry, yes.
I'm sorry. Is there any data being collected in terms of how long it takes to complete those investigations within the 90-day timeframe?
I don't know that, I think there has been some. Internal Affairs would have some, yeah.
That will be part of the upcoming meeting, is Commander Boddicker will be going through our annual report and going through all of those stats, yeah.
And so if it's not completed within 90 days or within the time frame that the parties agreed they would extend it, then anything that results from that, the member can't be disciplined. And that's basically what we're saying. If you don't complete that investigation within 90 days, you're pretty much out of luck if it's a disciplinary issue. And then it's probably helpful, and again, we'll get into this in more detail, but the flow of an IAB investigation. So IAB conducts its investigation, finishes it in a timely fashion, and then it has to go to the chain of command for review. It's what we call it hits the chain. Once it hits the chain, the investigation is concluded. It's done. Chain of command gets to review it. They're not subject to the same 90-day time frame. They can take as much time as they need. The chain of command, and it starts at the lowest level and then works its way up the chain. Each person in the chain reviews the investigation, makes their recommendations, and passes it forward. When it gets to the deputy chief level, the deputy chief actually makes findings on each of the allegations, recommends discipline or charges, and it goes back to IAB. One of the things that can happen is that during the chain of review command, they might have questions and say, hey, we want additional information. So it goes back to IAB. Then you might ask, well, what happens to the timeframes at that point? Well, we've had one arbitration that said, well, it still has to be 90 days. So let's say that you completed the investigation in 80 days and it hit the chain. It goes up, it goes down, comes back to IAB, and they say, hey, we need additional information. Can you investigate this? The arbitrator's like, that's fine, but you still have to have it done within 90 days. So if it hit the chain in 80 days, IAB only has an extra 10 days to investigate. Makes it difficult for IAB.
How many individuals are in the IAB group? And then approximately how many complaints or charges do they have a year?
So those sorts of questions, that's our next meeting with the commander going through in great detail.
Yeah, get it working.
The contract would be to put the framework that all of that operates in today with the collective bargaining. And then
But
we'll
there-
get to the nuts
yeah.
and bolts.
There-
Exercise patience.
Okay. But there's a commander, I believe there's two lieutenants, and how many sergeants?
We handle roughly 315 last year.
Thank you.
So again, if that investigation isn't complete in the 90 days, again, and that's not if it's criminal, we don't worry about the 90 days. But if it's not criminal, if it's not finished in 90 days, we're pretty much out of luck. Then if you take a look at Article 9, we have articles that deal with internal investigations, that's Article 8, and then external investigations, that's Article 9. So if a city entity other than the Department of Public Safety initiates an investigation against a member, we did have an EEO office and they could conduct investigations against a member. If the department orders the member to participate, then all of the requirements of Article 8 have to be followed. So even though you've got a city entity outside of public safety, they still would have to adhere to everything in this contract.
That.
Yes, let's say that there is a civilian employee in police who alleges that her sergeant has been sexually harassing her. And instead of going internally through the Division of Police HR, they go to city HR and say, I want an investigation. City EEO would absolutely be able to do that. And they would obviously want to talk to the sergeant. If safety ordered the sergeant to participate, then they get all of the requirements of Article 8. The safety director doesn't have to order them to do that, though.
Okay.
So he could say, I'm not ordering him to do anything, and then it's up to the individual whether they want to participate or not. Then Section B, somebody outside the city initiates an investigation. Again, the division could order somebody to participate. They don't have to, but they could. And if they do, in that instance, they're still entitled to lodge representation, but they're not entitled to all of the parameters and procedures of Article 8. So then Article 10, and again, we'll go into this in a lot more detail, but this is corrective action and disciplinary action. And you can see the first thing here is that you can only be disciplined for just cause. And those are always going to be pretty much on a case-by-case basis. If it gets to arbitration, the arbitrator is going to be looking, though, for the similar things in each case. Was there a work rule, a policy, a procedure, a division directive out there that governed the conduct? Division of Police operates pretty much pursuant to their division directives. We also have city work rules. So is there a city work rule, for example, against dishonesty? Yes. Is there a division directive or a rule of conduct against dishonesty? Yes. So was there a policy? Was that policy reasonable? Yeah, we don't want people stealing from us, so it's reasonable to have a policy, little bug, that says you can't steal or you must be honest. Did the employee have notice of that policy? If you've published it, division directive, work rule, they're up there, they're on the intranet, you can see them, that's notice. Was the conduct investigated? That's what IAB does. Was it a fair investigation? We like to think that all of our investigations are fair. Was there actual evidence that the person committed some misconduct? That's what the investigation would show. Then was the policy consistently applied? We're looking for disparate treatment. If I can steal $10,000 and get away with it, but you can't, then we haven't consistently implemented our policy or procedure. It's going to make it difficult to uphold an arbitration or a discipline. Was the discipline reasonable and proportional to the action? Let's say that I have one day of AWOL and I was 10 minutes late and you fire me and that's the only thing I've ever done. Arbitrator's going to say that's disproportionate to the offense. So we're looking for just cause. It's called the 7 tests of just cause. Most cities, most collective bargaining agreements follows that, and that's what we do here. The city also has a policy of progressive discipline. So unless something is critical misconduct or insubordination, the division is mandated to start at the lowest level of discipline. So after we get past positive corrective action, which isn't discipline, we're looking at a documented constructive counseling, written reprimand, suspension, demotion, termination. Those are the things. And we pretty much go up that chain, so we don't start at termination, we don't start at suspension unless there's something really serious going on.
Are there times when that process is suspended? Let's say you get a written reprimand but don't have anything else for 3 years. does that written reprimand go away?
Yes.
Okay.
Yes, and we'll see that a little bit later on in this section. So the chief of police can decide that a different sequence in discipline is warranted based on the seriousness of the conduct, but that is up to the chief. It's not up to a sergeant or a lieutenant or a commander or even a deputy chief. It's up to the chief to deviate from progressive discipline. The contract requires that discipline be issued at the lowest level. So sergeants actually have the ability to do a documented constructive counseling or give a written reprimand. But the contract also gives upper-level supervisors the ability to review what that person did and determine whether or not that was or was not correct. I'm going to skip over the probationary period. Certainly.
And it's kind of following off of Dr. Wilkinson's question in that, how long does a reprimand or any other progressive discipline live in the individual file of an officer before it goes away?
Yep, right here.
Oh.
So we're looking at 10.10, retention of records. Ooh, that was great. Yeah. Be a tag team here. Documented constructive counseling stays in the division personnel file for at least 1 year following the date of the incident which gave rise to the documented constructive counseling, as long as nothing else has happened. So if I did something on January 1 and I got a documented constructive counseling for it, January 1 the next year, that's going to come out of my file. Then we move on to written reprimands, and fleet safety records deal with when people have been in an accident with their cruiser. So you can see that written reprimands stay in your file for at least 3 years, provided nothing else has happened. Suspensions stay in for at least 6 years. And then we have demotions and terminations. So what the division does on a routine basis is go through personnel files, and they actually purge those. So they try to make sure that they're adhering to this, so that if somebody makes for example, a public records request of somebody's personnel file, they make sure that that information, it's a little bug, is out of that file. That's their mandate to do that. Destruction. Mm-hmm.
One particular thing, if if it has been found that an officer exercised, I think it's unlawful use of force,
Okay.
right? So, I mean, there's a case that I'm thinking of recently where that's what the arbitrator did, is in fact find that it was excessive use of force, not enough to justify firing. How long does that stay in your file?
It depends on what the ultimate action was. If it was a suspension of any, length of time, then it would stay in there for 6 years. So when we're looking at this, we're not looking at what is it that the officer did. We're looking at what was the level of discipline that was meted out. And
Still in the public record.
the fact that there was.
Are the previous disciplines, even though they've gone away from the file, in the public record somewhere?
Yes. It's a little bit confusing, but because they are public records, we can't destroy them. But they are taken out of the file, and you'll see here in Section I, and this is some very confusing language that, to be very honest, nobody's quite figured out. We take those out of the file, but they are maintained elsewhere. But they're not in the personnel file. But we can't just destroy them. We have to wait until the appropriate records retention schedule comes along.
Is there a way for a member of the public to sort of adequately request records that have been removed from the personnel file that may still be retained? Because it seems to me like there could be a problem with a member of the public being able to request the right document that they're looking for.
Yeah. You could request it, I think, through IAB or professional standards. Public records, yeah. So there is, yeah, division does have a public records office. But what you wouldn't want to say is, give me the personnel file, because if it's after 6 years, it's not going to be in the personnel file. We do have one exception, and that's the legal action exception. So if somebody has been dishonest, there's been a finding of dishonesty, those records are going to be maintained. And that deals more with what goes on with the prosecution. If we're having if somebody has sued the city or somebody is on trial for something, and the arresting officer has a dishonesty finding, the city has to turn that information over to defense counsel. So those records are all maintained. We don't ever get rid of those. And that's what you see here in section L, records of sustained finding of untruthfulness. So notwithstanding all of the records retention schedules that we have in here, we're going to keep those records. I'm trying to find. So then if we want to move on to Article 12, that's the grievance procedure. And so we talked a little bit about the fact that every contract has to have a grievance procedure. This is the grievance procedure with the FOP. A grievance is any unresolved question or dispute regarding the city's interpretation or application of the contract. So when we get to arbitration, we have basically two types. One, what we call a contract grievance. They're alleging some violation of the contract. But our disciplinary decisions are also subject to the grievance and arbitration procedure, even though it's not necessarily specifically defined that way. That's what it is. So either the lodge or a member can bring a grievance. The process has 5 different steps. Step 1 is the immediate supervisor. Step 2 is the deputy chief of police. So let's say they go to step 1, they talk to their supervisor, the supervisor says, "I've denied the grievance," they're unhappy with that, they can move up the chain, so they keep going that way. They can get to the chief of police, and then ultimately to the director of the Department of Public Safety. If they're not satisfied with that answer, then they can go on to arbitration. Only the lodge can move a grievance to arbitration, though. So an individual employee can't say, "Well, I don't like the safety director's answer, I want to go to arbitration." They can't. They don't have the right to do that. Only the lodge can do that.
And that may be a little, what is the difference between a discipline, which you talked about a moment ago, and a grievance?
Well, discipline, the decision actually starts at step 4. So they don't have to file a grievance, a formal grievance over discipline. It starts at step 4. So if a person is suspended by the safety director, that's considered a step 4 answer, and that can be moved to arbitration by the union if they want to. With the others, they actually file a written grievance. It's got to be in writing, has to be signed, and it goes up the chain, and it follows all of the normal processes and all of the timeframes that are in there.
In more elementary, grievance is when an employee believes that the employer isn't following the contract.
Yeah, let's say that somebody thinks that they were inappropriately reassigned by the chief of police. That could be a violation of the contract. They might go ahead and file. Let's say that they think that they, for some reason, didn't get their uniform allowance and they should have gotten it. That could be a grievance. They could go on with that. So we have contract grievances, and then we have discipline. So when we get to arbitration, I explained a little bit about how we select the arbitrator, and we have our permanent panel. The arbitrator doesn't have any authority to add or subtract to the contract. They have to follow the terms. But of course, they're giving their interpretation of what these terms mean. So the way an arbitration proceeds, if it's a contract question, the union has the burden of proof. So they put their case on and they say, "Mr. Arbitrator or Ms. Arbitrator, here's what we think happened and here's why we think we're right." My group comes on and we say, "Ms. Arbitrator, here's what we think happened and here's why we think we're right." Arbitrator listens to that. We have witnesses. Arbitrator takes that away, and 30 days later we get a decision. Arbitrations are not public hearings, so only the parties involved are there. They are not recorded. There's no transcript of those. The arbitrator might take notes, but those are only for the arbitrator. They don't get transcribed and moved to other people. We don't see those. And so the arbitrator makes his or her decision. They're supposed to give us the decision within 30 days. I would say that seldom happens. But it is final and binding arbitration, so once we get that decision, with very, very limited exceptions, we're stuck with it. We do have the ability to remove arbitrators from the panel. Either the city or the lodge can remove an arbitrator if they've issued at least one decision. The parties can mutually agree to remove an arbitrator, so FOP and city could get together and say, hey, for whatever reason, we think we don't want this arbitrator anymore, we can do that. But if you're doing it just one party, no party can remove more than 3 arbitrators during the term of the contract. And then lastly, that we wanted to touch on, I'm not going to scroll all the way down there, it would take too long, is 38, the midterm bargaining. But you've got a copy of that, and that's what Ron was talking about. You can see how those processes work. We want to make changes during the term of the contract, and it's something that's not included in that contract. 38.4 talks about how we do the midterm bargaining process. Again, this is all set out. It's not complicated. Sometimes things can go wrong, and that's how we end up in grievances or arbitration. But for the most part, the roadmap is in the contract, and if we follow the contract, that's what we're obligated to do. That's what the FOP is obligated to do. And I would say for the most part, it works out well. We don't always agree, but, you know, that's the nature of labor relations. So that's all I have in terms of the specific contract articles. If there's something in particular you want to ask me about, I'm happy to do that. I'll show you the table of contents just so you can see the scope of information that's included in here.
Where is the lodge? So it says in here, it says the police facility or the lodge office?
They are out on, are they on 161? Yeah, Schrock Road.
161 Schrock.
They actually have a physical office out there, yeah.
Okay, just curious, thank you.
So you can see, and again, the contract is online, public record. Go to the city's website and just click on Human Resources, Labor Relations, and you'll see it. But here's sort of the scope of what's included in this contract. We've talked about some of these things. Non-discrimination clause, assignments and transfers, a labor relations committee. There's a committee that meets routinely of management and labor to talk about issues. Work rules and division directives, when those can be changed. Promotions, no strike. Alcohol and drug testing. Wages, obviously. Hours of work and overtime. Holidays, vacation. So pretty much every term or condition that you could think of is included in this contract. Any questions?
Just as a thought, in this section 8 where you're talking about investigations, and IAD is your internal group that does those, right? If there's an officer involved shooting, you can potentially go to BCI to have them investigate instead of IAD.
I'm not aware of the city ever sending an investigation like that outside the division. I'm not aware of it.
Okay. As other police departments do, especially with very serious cases like that. So there is not the illusion of collusion, you know.
Yeah, I'm not aware of the city actually having done that. I suppose under Article 9, if some other entity started to conduct an investigation, we could look at that, but I'm not aware of the city actually saying somebody else come in and do this investigation.
And this is a little different, and quite frankly, it's sitting somewhere in the legislature. I think I mentioned this to the commission early on. So at least 2 years ago, I served on a task force that was convened by the Chief Justice of the Supreme Court, and this would only deal with fatalities. But out of the recommendations, it essentially, if there was a police-involved fatality, it would be removed from the county. The investigation would go to BCI, and the entire case would be removed to the Attorney General. Those were the recommendations. It's still sitting there. The county prosecutors, I believe, came out pretty strongly against it. I don't know if it's going to go anywhere, but those were, and the very specific concern was about the grand jury. Having the case brought before a grand jury by the prosecutor in that county. So it's out there, but I haven't seen any action on it at all.
But I've had some recent conversations about that, because some people, some agencies do want that degree of independence. So I wouldn't be surprised if that comes up as a statewide issue at some point.
I agree. Is there anything that prohibits that right now? If the chief of police said, hey, I want BCI to do the investigation, or whoever, is there anything that in the contract or policy that does not allow them?
I think the contract right now would require it to be done in-house, yeah.
Interesting.
Is there any language in the contract that prevents the city from separation with the individual officer if they're identified as co-defendants in a lawsuit?
Say that again?
So if an officer and the city are named as co-defendants in a lawsuit by a citizen, can the city separate from that officer if they want to defend themselves individually from the officer in the union defending the officer?
It depends on the circumstance. Under Revised Code 2744, the city is required to provide a defense for an employee, not just FOP employees, but for any employee, as long as they were acting in good faith and not in wanton, reckless disregard. If the city and an officer are named in the same lawsuit, and the city believes that the officer meets those requirements, then we probably would stay in there and we would not separate that person out.
Or what could happen is happened in the past. If a city believes that there's a conflict with that officer, there is still the duty of representation. And what the city does is they do the separation, but then the city pays for that outside attorney to represent the officer.
Okay,
So,
yeah.
And let me go back to some, so use of force will be covered in upcoming, and we're going to be getting into how uses of force are investigated, and we can certainly get into outside agencies. There's the legal, and there's also some practical issues with respect to outside agencies. Let's just, for example, it's 3 a.m. in the morning. There's some difficulties getting BCI here on Christmas night. And there's some capacity type issues and timing issues too.
Kind of along those same lines, does that same sort of contracting out in the case of conflict occur if maybe two officers are like named in the same suit but are essentially don't have the same interest?
If they're acting in good faith and we have a duty to represent them, we might assign separate counsel within our office to do that so that there's not that conflict and we build that wall. Because certainly there are times when officers' interests are not aligned and one person says, I don't want to be represented by the same lawyer that's representing X. If we have a duty to represent them, we will get them counsel. And we would analyze that like you would any other lawsuit. It doesn't necessarily mean the FOP, but if defendants don't have the same interests, then obviously they can't be represented by the same counsel. Anything else?
Are there any other questions? Well, thank you, and we look forward to having you come back to us. Okay. Do we know when that is and has that been? Do we need a meeting to figure out the schedule? We haven't had one of those. Usually there's sort of an in-person meeting when we determine the topics for the next several meetings. So it's probably time for that, Elon. Is there anything else from the commissioners at this point? I mean, in terms of discussion? Yes.
And this came up, and I think Aaron asked it in our subcommittee meeting. And I wanted to ask it on record here is that our subcommittee meetings, are those public body record provision kind of meetings in that there's more than two commissioners meeting So is there some requirement that our minutes be made public and our conversation be made public? And is there,
Probably so. Minutes should be kept.
We took minutes of the meeting in the event that they needed to be, so.
right,
We just want a
We
clarification on
will
it.
to look at it carefully, because we're not like the elected city council or the elected county commissioners, where I would feel much more comfortable answering that. So why don't we go back and check it out? I don't want to just kind of shoot from the hip on that one. It's a very important question. We need an answer before the next meeting,
yeah,
okay?
thanks.
Any others? I know that over the last day or so, the commissioners have been polled for the next meeting. I don't know if it actually meant that we were moving from one date to the next. I know that we have an issue around an outside consultant not being available when we were going to meet. So I think the poll is out there for November the 14th, either morning or afternoon. Do we know yet?
When I left the office, the majority needs the afternoon.
Okay, all right. And again, that's fine. I was available the entire day, but we will let you know as soon as possible, because that's almost within a 2-week, time period. Any other procedural matters, et cetera? I don't believe this. We're going to adjourn almost 55 minutes ahead of schedule. Tracy, are you going to say something to stop that? Well, I hope the rain has stopped or at least slowed down, and that you have a very pleasant evening, and I will see you on the 14th.